now something completely different. Being the last speaker on a Friday afternoon, it's really challenging. I'm also under a contractual obligation to tell you what UNCITRAL is. So the United Nations Commission on International Trade Law was established by the UN General Assembly 50 years ago, almost 50 years ago, and the mandate is to further the progressive harmonization and modernization of international trade law. The Commission has 60 member states rotating, and the membership is structured to be representative of the different geographic regions and also the different economic and legal systems, which of course includes Islamic influence jurisdictions. Just for your reference, Indonesia and the Emirates were members of UNCITRAL from the late 60s, since the beginning, and till the late 70s. The Kingdom became involved in 92 till 98, and Bahrain, Kuwait, Malaysia, and Qatar became involved with UNCITRAL work since 2000. Of all the Asia-Pacific Islamic influence jurisdictions, only Oman and Brunei have yet to become members of UNCITRAL. So the adoption of UNCITRAL standards, because of its particular intergovernmental lawmaking process and the different modalities of adoption, of a rule-based trade system, promoting the rule of law and access to justice, and doing so, delivering two decisive factors for any policy aiming to improve governance, having also an important side effect of raising the capacity of the legal community, especially in developing countries, as well as raising the standards within the local judiciary. I will share a brief overview of the implementation of three UNCITRAL texts. UNCITRAL is not only arbitration, by the way, and has more than 20 texts. And those three texts, I will share an overview on what we consider Islamic law influenced jurisdictions in the Asia-Pacific region. The first one is, of course, one of the most successful international treaties in the history of mankind. It's the New York Convention, as Joao said, with 155 member states. And the second one is, of course, the model law that was approved in '85, the first one, to ensure harmonization of commercial arbitration and to ensure also uniform interpretation and implementation of the New York Convention. Let me say that this was done in '85 and amended in 2006 with inputs from arbitration experts coming from common law, from civil law, and also from Islamic law traditions. And finally, my hidden agenda for today is the CISG. And I know how challenging it is to talk about the CISG with common lawyers. But the United Nations Convention on Contracts for the International Sale of Goods is currently ratified by 83 states. This gives you a little bit an overview of our scope. The regional center of UNCITRAL was established only 3 years ago, and it covers, was established in the Republic of Korea, and covers regionally from Lebanon to New Zealand and all the Pacific Island states, covering 56 jurisdictions. Among those, we can consider 23 jurisdictions are, of course, to different extent influenced by Islamic law, which accounts for 41% of the jurisdictions under the mandate of the regional center. As you can see, the New York Convention and the model law are widely adopted in these jurisdictions, as well as the model law, for instance, on e-commerce. On the other hand, none of these jurisdictions adopted, for instance, the model law on public procurement or the model law on cross-border insolvency, nor the Rotterdam rules. I will provide a very brief overview of the implementation of the CISG, the New York Convention, and the model law in 3 ASEAN states, Brunei, Indonesia, and Malaysia, and in the Gulf Cooperation Council member states. Well, a lot was said. Being the last also allows to skip a couple of slides. I would just add to what was said that it is fair to argue that in Islamic law influenced jurisdictions, these jurisdictions might be actually better equipped to deal with the concept of alternative dispute resolution due to influence of Sharia principles, actually. And sometimes I hear that arbitration and ADR is a very new concept, and I always get hugely surprised by that, because when I studied law, I was told actually that arbitration and mediation were the backbone of any legal system before they became institutionalized and became what we know today as civil law or even common law. In any case, going forward, because we heard enough of it, I would also say that the majority of the jurisprudence schools hold the opinion that arbitration is fully permissible. I am aware that some jurists within the Shafi school hold the view, for instance, that arbitration is not permitted when there is a judge available, or that argue that arbitration is never permissible if it is the basic function of the great imam or anyone whom he has delegated such function. There are also good views challenging this stance. But again, this was widely discussed, so I will move forward. So, in Brunei became a party of the New York Convention in '96 and has a reciprocity reservation. It deals separately with international and domestic arbitration, and in 2010, of course, promulgated the Arbitration Order of 2009 and the International Arbitration Order also of 2009. And these are the laws governing arbitration in Brunei, based both in the UNCITRAL model law from 2006, and they are very clearly intended to prevent court interference in the arbitral process and promote its role as supporter of arbitration. In December 2014, also the Sultan of Brunei approved the creation of the Arbitration Center of Brunei. Indonesia became a party to the New York Convention in '81 with both the reciprocity and the commercial reservations, and the first legislation enacted was the Indonesian Arbitration Act number 30 of '99. It makes special reference to international commercial arbitration under Chapter 6, Part 2 of the '99 Act. In principle, this was well designed to recognize the finality and enforceability of international arbitration awards. The idea behind it was to limit the court's intervention in the arbitration process while enhancing party autonomy. The enforcement of international arbitral awards in Indonesia is also regulated by the Supreme Court Regulation number 1 of 1990. Although these provisions seem to support the enforcement and the finality of arbitration, in practice some issues need to be addressed, such as the non-exhaustive nature of grounds for annulment under the Arbitration Act of '99, which might undermine the finality of foreign arbitral awards. Indonesian courts often construe widely and at times equating public policy with good morals. This construction of public policy is exemplified by the ED&F Man Sugar Limited case, where the Indonesian buyer successfully prevented the enforcement of the foreign arbitral award for breach of contract. The basis upon the Indonesian court relied upon for the non-enforcement was the notion of public interest. The reasoning was the enforcement would result in a conflict with domestic laws passed within Indonesian for the regulation of sugar prices. Well, in Malaysia, you know better than I would just say that the courts have been taking a broad interpretation of things that are arbitrable, and also being very strict when considering public policy arguments. On a side note, I would just add, taking the chance that I'm in Malaysia, that Malaysia could consider the withdrawal of both reservations, the reciprocity and the commercial reservations. I would say that arguments for withdrawing the reciprocity reservation are a bit self-explanatory when we are talking about a convention with 155 parties. And I would say that politically, the withdrawal of the reservations would also provide for a push and higher awareness of Malaysia as an arbitration hub. A large number of member states at the GCC have become members of the New York Convention, and but however, many still treat foreign arbitral awards as foreign judgments. This subjects the arbitral awards to the reciprocity requirements applicable to foreign judgments, and enforcement can be denied for failing to enforce domestic judicial decisions. Several states with Islamic influence law base their arbitration laws on the model laws of UNCITRAL, namely Bahrain, Djibouti, Iran, Jordan, Oman, Tunisia, Turkey, Zambia, Egypt, Saudi Arabia, and the Emirates. In 2012, Saudi Arabia adopted a new arbitration law, generally based on the UNCITRAL model law. And in 2005, Qatar also introduced arbitration laws based on the UNCITRAL model law, though only applicable to the Qatar Financial Center. Of course, you all know that Qatar is currently revising its arbitration bill, and the new draft bill intends to repeal Articles 190 to 2010 of the first book of the Code of Civil and Commercial Proceedings. Some states have even based their international arbitration laws on foreign jurisdictions, including Lebanon, that has adopted the French law of arbitration of 1981, or Algeria, that derived its 1993 arbitration law from a combination of French arbitration law and Swiss private international law. In Iraq, the Civil Procedure Code applies to any arbitration in Iraq, regardless of the nationalities of the parties. The Iraqi courts have refused in the past to enforce foreign arbitral agreements, which has resulted in some seeking to enforce the foreign arbitral awards as foreign judgments. As for Kuwait, the legislative framework that governs the arbitration is codified under Law Number 11 of 95 concerning judicial arbitration in the civil and commercial matters, the Judicial Arbitration Law, and also Law Number 38 of 1980 that approved the Civil and Commercial Procedures Law. In Kuwait, sometimes foreign arbitral awards are treated the same as foreign judgments, and hence must not contradict the ruling in Kuwait and cannot be contrary to public order or good morals. Such regulations of arbitration and foreign arbitral awards tend, of course, to stifle international investment, as most commercial activities in these states often involve state-owned enterprises, and investors are hesitant to engage in projects unprotected by foreign arbitral agreements. As I told you, this is my hidden agenda. I'm taking the chance to promoting CISG in Malaysia, and hoping also that next year during the arbitration week we can have a session on CISG. I know it's asking too much. So you probably, I'm not sure how aware you are, but CISG is actually a very successful convention with more than 80 parties, 83, and it has contributed a lot to introduce certainty in commercial exchanges and also decreasing transaction costs, namely for SMEs. We can say that 90% of the signatories are leading trade nations, and an estimate of 70 to 80% of all sales transactions are potentially governed by the CISG. Currently, most of Malaysia's top trading partners in 2014 have become members of CISG. Furthermore, Indonesia, Thailand, and the Philippines have expressed at the highest level a growing interest in the adoption of the CISG, and I must say that the regional center of UNCITRAL is working very closely with these governments to make it possible within the next 2 years. In Malaysia, as you know better than I, you also need for some kind of uniformity. You have also differences in the way you regulate the sale of goods, both in Peninsular Malaysia and East Malaysia. Also, for the case of Brunei, the top 10 origin of imports are Malaysia, Singapore, US, China, Japan, Thailand, Indonesia, Germany, Republic of Korea, and UK. 6 out of 10 are CISG jurisdictions. Like Malaysia, Brunei's laws are based upon common law and as Sharia law to deal with matters pertaining to Islamic matters. The Sale of Goods Act of '99 is almost identical to foreign law and was not influenced by the CISG. In Indonesia, it's a little bit different since Indonesia is predominantly a civil law jurisdiction, and at present, the law governing the sale of goods contract is the Indonesian Civil Code. The legislation is widely recognized as being insufficient to deal with international sale of good contracts, as it does not reflect modern international practice. As a result, most of international sales contracts involving Indonesian parties have chosen the laws of the foreign party as the governing law of contracts. The importance of a proper legislative framework for the facilitation of international trade is recognized by the Indonesian government that commissioned an academic draft and has recognized that Indonesia should join the CISG. For the purpose of the ASEAN Economic Community, it is suggested also that the CISG could be used as the basis for a much-needed harmonization of contractual sale of goods within ASEAN member states. Firstly, because the CISG is in conformity with international standards, and secondly, because the CISG represents a compromise between civil law and common law jurisdictions, and its terms are also highly compatible with Islamic law. In Malaysia's case, the ratification of the CISG not only allows for harmonization with international law, but it could also be an opportunity for modernization and harmonization of domestic laws. It also bridges differences from market-driven economies and socialist economies, allowing for smoother legal adaptation in transitioning economies, as it is the case for Cambodia, Vietnam, Laos, or Myanmar. The adoption of the CISG as basis for harmonized law would enhance the predictability and stability of judgments or tribunals' findings within ASEAN, providing greater investor confidence in the region, and would of course develop regional jurisprudence. As arbitration is also more likely to be brought in arbitral centers, which provides for arbitration of the jurisdictions of which the contract is governed by, the promotion of Malaysia as an arbitral hub is likely to lose out to other regional arbitral centers, since the majority of the world's trade contracts are potentially governed by the CISG. The ratification of the CISG can not only standardize international contracts in Malaysia, but can also be a push for promoting Malaysia as an arbitration hub. It also levels the playing field, the bargaining contractual power. A recent survey showed that the 5 big trading Japanese companies opt out systematically of CISG because they use model forms or they have large legal departments and they choose the New York state law almost always. What is easier for SMEs to be familiar with? National laws that follow an international standard like CISG, or a law from a federal state of the United States of America? Unlike large corporations, small and medium firms do not have the financial ability to maintain a legal department and is more likely to be drawn into a biased contract. However, the CISG is recognized as a fair contractual solution, and its use by SMEs when dealing with large corporations could prevent falling prey to aggressive contractual practices. While looking to the Gulf Cooperation Council, they have taken significant steps towards the harmonization of legislation, such as the signing of the economic agreement between the GCC states in 2004, while the agreement does not provide for an harmonized law governing contracts on the international sale of goods. While the differences in the legal system of the GCC member states are not as extreme as those of the ASEAN states, the differences would still hamper international trade. The adoption of the CISG by the GCC members could assist in harmonizing not only the laws between the GCC member states, but also between GCC member states and international best practices. Only in GCC states, only Bahrain is a signatory to the CISG, and despite being a signatory, there has yet to be any CISG case involving a court. Of course, I know what many are thinking: the lack of popularity of CISG among the GCC states is likely to be related to the inability to make reservations to Article 78 of CISG, which might contradict, or it does contradict, Sharia principles. Another potential problem involving the CISG and Sharia compliant contracts relates to the types of goods being purchased and sold. Under Sharia law, there are certain goods which are deemed haram and hence illegal. However, it is unlikely to be an issue since the CISG Article 4 provides that CISG does not apply or deal with the validity of the contract. While the contract on the sale of alcohol or other haram products are governed by CISG, they could still be invalid depending on the local laws of the state. Let's take a closer look to Article 78 of the CISG, which is argued incompatible with Sharia law. Article 78 indeed provides for payment of interest, and the Convention does not allow to make a reservation on it. This was an issue actually raised by some Arab countries' delegations, and it was suggested that the CISG make no reference to interest, or at least provide a reservation for Article 78, as it goes against the Holy Quran, which prohibits riba, which is the source of all Sharia law. It would seem that the 6 Islamic influence jurisdictions from the Gulf and Middle East, Egypt, Iraq, Lebanon, Syria, Turkey, and Bahrain, that have ratified the CISG did so by adopting them into their national laws. For instance, in Egypt, the adoption of the CISG was done through the publication of the Arabic version in its official gazette and has become part of its national law without changes made. On this regard, I would leave for your consideration 2 thoughts. The CISG has not only been adopted as a treaty, but many times has been an inspiration and a model law for contract law reforms. And if countries wish to adopt national laws following the CISG without signing it or ratifying it, that would also serve a purpose of harmonization and unification, which means that even like this, each jurisdiction constrained by Article 78 can ignore it in its national reform. Secondly, the growth, as we heard today, of Islamic finance has seen the introduction, as we also heard, of a new compensation mechanism for late payment. The I-Arbitration rules at KLRCA provide for the option of using a late payment option, known as tawid, which is used in Islamic banking. The underlying principle behind this is that a late payment by the debtor results in a detriment or loss to the creditor, and tawid is intended to compensate for that loss. This is recognized by the Sharia Advisory Committee of Malaysia, subject to certain conditions, of course, which are consistent with late payment compensation. The adoption of this principle is likely to prevent a conflict between Article 78 and the principles of Sharia law, while providing the seller for a compensation as a result of late payments. This, in conjunction and taking into consideration Article 6 of the CISG, that the parties may exclude the application of the Convention or derogate from or vary the effect of any of its provisions, maybe the use of tawid for compensation of late payment in a sale of goods contract agreed by the parties would allow to overcome the barrier imposed by Article 78. Although in some schools the legality of tawid is subject to controversy, as some consider it unlawful, the underlying concept is not new and has been accepted, for instance, in Saudi Arabia. In 1993, a Saudi arbitral tribunal held that riba did not bar all awards of compensation for financial loss due to a party not having had the use of a sum of money, and the doctrine of riba does not preclude an award for the reasonable compensation of this loss. The interest rate imposed in that case was not the commercial interest, but rather the annual inflation rate over the period in issue, similar to the way tawid is calculated. This is really a very brief overview and food for thought, And I would close saying that there is still a long way ahead to promote the harmonization of arbitration regimes, or even to unify domestic and international commercial legislative frameworks, and even to ensure uniform interpretation. And the longer road when we consider the lack of uniformity for a simple sale of goods act, a very simple contract. But all of this needs to be seen in perspective, and a wider perspective that very often lacks to the arbitration community. The key for the success of the system is legitimacy. And this legitimacy of the system and its recognition by the end users is the key for the working of the system. As a political organization, the United Nations would have no interest in the harmonization or modernization of international trade law as such, if it was not convinced that such work is conducted in pursuance of greater goals, such as the promotion of the rule of law, and of course, access to justice, and ultimately of peace. I will be very happy to address any questions that you might have. Thank you very much.